All right. Hello, everyone, and happy Wednesday. My name is Maddie Horsby. I'm the project manager for the Riot organization. Welcome to the Riot Lunch and Learn series, the place where we spotlight Riot sponsors. Today, we have with us Maks Ewendt to speak about legal agreements and how to protect your company and keep your money. Very important. Just a couple quick reminders before we get started. This event is being recorded and will be posted to Riot's YouTube channel and uploaded to the meetup page where you registered for this event. If you have any questions throughout the presentation, feel free to throw those in the chat and I will let Maks know, and then he will answer those throughout the presentation. And please keep yourself muted throughout the entire event. At the end, we will invite you to unmute yourself and we'll do a little bit of a Q&A. But with all that being said, I'll throw it over to you, Maks. Thanks for joining us.
Thanks, Maddie. Hello, everybody that can't say hello back to me. Sorry about that. My name is Maks. I'm with Fourscore Business Law. I like to talk about agreements, contracts for your business, something that I'm very passionate about, which is weird because I never thought I would have that many thoughts about contracts, but here I am. A little background just with the firm itself, if you're not familiar. We work primarily with small businesses, startups, high growth businesses that focus on innovative processes, either it's technology or otherwise. Anybody that has a plan to do something exciting, we want to be a part of, because it keeps our jobs exciting along the way, which may be why I enjoy the contract so much. Everybody's innovation requires me to be innovative when we're trying to work with them and their clients, business move forward. A little about myself. Law is actually a second career for me. Previously, I was in technology, software sales, including software as a service, and management. And as I went through that exciting time with small companies and startups, a lot of conversations I was interested in were on the legal side with our general counsel. So I made a switch to go to law school, focus on transactions, small business, high growth clients, and pursue that afterwards, which has been a great fit. I think it helps me appreciate what our clients are going through as they're getting going and understand what all the clauses and terms are meaning in those contracts to help, again, communicate and understand to our clients and find those solutions as we try to protect ourselves as much as we can, but also not inhibit the business as well, which is usually the opposing factors. I'd like to start off everything with this timeline that I picked up along the way, kind of a timeline for a company's excitement level over time, because not everybody knows what we're getting into right off the bat. So it kind of helps set those expectations along the way of the exciting times and the events are usually happening with them, and also kind of where legal help resources come into line with those as well. So if you ever feel yourself getting really excited or really not excited, might be a good time to think about, do you need to engage an attorney to see if there's anything they can do to help support that, for better or worse, as will happen along that path. So today, talking about agreements and when do we need an agreement of any kind? The lawyer answer is going to be, it depends. A lot of times we get questions from our clients of, do I even need an agreement here? And may not. Agreement can be anything from a handshake up to your 160-page document with exhibits and attachments and colored glossies with handwriting on the back of them. And there's a spectrum of what is needed and what's expected depending on what stage you're at. Towards the handshake side, it's an agreement. And if you are working with a babysitter who says, I want to do this service and I'll pay you this much money, or you pay this much money, that is a contract, it's binding. Really quick for initiating the business, no hurdles there. There's not a lot of protection. If something goes wrong, nobody knows what's going on. All you're left with is the service and the funds being exchanged. On the other end, if you can, kill a deal, turn off the other party if your agreement is too overbearing. The resources it takes to get some of these contracts and agreements just isn't worth it, even from the legal side. And the goal is to balance out the business needs with legal protection, with the risk association with that, to figure out, do I need an agreement? And if I do, what kind? And my general rule of thumb is you need an agreement anytime there's a transfer of value, which gets us away even from if money is involved or not, because there's going to be protections. And that usually comes down to a transfer of ideas, the transfer of equity, and then transfer of money is the easy one. So as you're moving forward with your business and your business decisions, if any of those three things are being transferred or being shared with somebody else, it's a good opportunity to flag to yourself and say, hey, I may need an agreement for this. Why do you need an agreement? In case something happens. Hopefully, you never do. The contracts, agreements you start with, the arrangements you have with your other parties, everything goes fine. And there's no need to go back to that contract, but you definitely want to have it in case something does. One of the main features of a good agreement is that hopefully it contemplates everything that could go wrong and what would happen in those circumstances. So if there's a liability problem, if there's a service that didn't happen, if there's a payment that was delayed, go ahead and write all those things down. And then what happens if that goes the wrong way, so that you get to avoid going to litigation, which is expensive, time consuming. Nobody really wins. The whole goal is to lose the less. So if you write in, if payment is late, it's a 1.5% interest rate on there. Great, it's already been figured out. You'll go fight about that later. When you use a good agreement, what I consider a good agreement, it also prompt questions that aren't always contemplated ahead of time. Fourscore has created a lot of templates to start from our own agreement types that kind of lead through those questions that may not have come up during the initial business discussions of what's going to happen moving forward. So if you go through that process, it really helps unveil some of those scenarios to either figure them out, or if you can't come to an agreement about what should happen in this case, maybe this isn't the best fit for you or the other party. But you know about that beforehand, rather than waiting 6 months into the agreement, then realizing it wasn't a good fit, but you've already got obligations, responsibilities you're required to do. And part of that is also the accountability beforehand. Nobody wants to rarely take on additional accountability when something's gone wrong. So what I do enjoy about the transactional part of the law is everybody's still pretty happy at that point. Everybody wants to make a deal happen and are excited to talk about worst case scenarios before there's actual liability, dollar amounts, timelines involved. So the more you can talk ahead of time in a positive light, everybody usually ends up being happier. So this is a broad presentation meant for all kinds of companies and types of businesses. So please take this in that light. When you consider what kind of agreements your company should have, this is kind of an overview to consider all the different avenues. To the left would be anything that's kind of, I consider it pre-business, to set up any kind of partnerships you may need to have to move forward. If you are selling a solution that takes multiple components, you may have suppliers, manufacturers that have their own agreements you need to adhere to. Even outside of any of those products, your company may have other vendors, even if you're consider where your office space is being leased from, if you've got vending machines, anything that could be exchanging to make your company whole in what you see, call it pre-business, will have agreements that you definitely want to have written down. Usually that's what you're paying for. So the liability shifts a little bit with what kind of terms you want to see. Kind of call it during the business, post-business is whatever you're selling or whatever you're providing, either services or solutions, but you're likely going to have, hopefully, clients who are paying for it. And then, if you start to develop partnerships, either from a marketing perspective or resellers, those are going to be separate terms with different situations that are coming up that you make sure you're speaking to differently than what your client agreement could be, what circumstances could be out there. On both sides, you'll see there's prospects, prospective suppliers, prospective clients. That goes back to the concept of the transfer of value through ideas, confidentiality, just non-disclosure agreements to make sure as you are talking post or pre-business that you're protecting what you have as a company. Even it may not be tied to a specific dollar, the transaction. You don't want to lose any of those trade secrets, any confidential information, any patent information that you make sure you're protecting either way. In the company itself, make that run. We talk about the transfer of equity. Usually that's going to be an investor or even an advisor. You'll make sure that you are setting out specifically what your expectations are for that kind of equity with each, what they're getting in return, and being clear about what those expectations are. We actually can include founders in there as well. We work a lot with our startup packages, make sure that founders represented in the way they expect to be, and that it's clear going into it what those requirements are, timelines for vesting schedules, and what can be confirmed with stock options to consider there, which also ties you into your employees, 1099 contractors that will come and go during your business, and how to address each of those appropriately, how to define them separately. A lot of questions come up between, is this an employee or is this a 1099 contractor? The agreements can actually help determine which one it is. If you're looking through a 1099 contractor agreement and a lot of the terms don't apply, it's likely not a contractor anymore. You need to shift looking at it as a W-2 employee, and there's benefits that are afforded to them as well. So high level, is looking at what kind of agreements my company should have in place. This is a representation. If you have any specific questions, by all means, we can discuss that as well to figure out how those will come into place. This is kind of a broad overview of what that could be. Within those relationships, you have those agreement types, again, tied to ideas, equity, money. You may hear these pop up more often than not. Some of them are a Venn diagram. Look at a non-disclosure agreement, could be called a confidential agreement. There's confidential clauses and regular agreements or standard agreements. So there's a lot of keywords that are out there, but this is kind of what they're accomplishing. When you're protecting your ideas, or having access to somebody else's ideas, you do want to have a non-disclosure agreement. Mutual is always great as far as keeping the parties respectful, because if one party is agreeing to do it, then these terms aren't so bad for the other party. Data transfer agreements, if there's no money involved, but you want to make sure that you're providing certain data types to another party, that they're taking the appropriate security protocols in place, and upon the conclusion of the agreement, either returning it, deleting it, whatever it may be, but make sure there's a clear end-user license agreements. When we start getting into usually software solutions, you can kind of consider that as any agreement to use a service as well, but usually deals are tied to software to stipulate how a client or another party can use what you have. Not always in exchange for money, but you'll make sure that they're not misappropriating any information you have, or using it in a way that's not intended that could increase liability. Website terms, privacy policies. If your company has a presence on the interwebs, those are going to be important to stipulate how folks can use what they see on the website, and also make sure it's clear what you're doing to protect their privacy. And we'll talk a little bit about agreements versus policies as well. And then operating agreements too. If you've got an LLC, either a multi-member or something in the corporation, we'll make sure that it's clear what expectations are there between the founders, how the company runs, and that's all written down. So if there's an issue down the road and we get dispute management, we have something to go back to, rather than trying to determine what the parties intended, or hopefully avoid having to go to litigation to figure out what common law would say or what's been codified. Equity we talked about a bit for agreement types. Advisory agreements, if you have somebody you want to bring on to help out in an advisory role, which usually somewhat limited participation but super important. A lot of times that's tied to equity, either as stock option or a grant. If you do go out and get investors, either angel, institutional, they'll have their levels of investor agreements for what they expect in return. Partnership agreements, again, also could be part of equity if they're just exchanging with their assets, their customers or contracts, they exchange to work with you as well. And then you have your money agreements, which covers most of the gauntlet for everything else. That's what most of us are here for. Sales agreements, reseller agreements, vendors as well, suppliers, partners. They get your employment types, contractors or employees themselves. Asset purchase agreement, outside of investments, if there's going to be a merger and acquisition, always tied to some agreement with different levels of complexity depending on what's contemplated and what the parties are trying to achieve. We're going to get a little more granular here, with the intent to arm you guys with good information so that If you're not in a position where you want to engage outside counsel to help as a resource, kind of understanding of the key clauses that are in there, and actually getting some hurdles and terms as well, to kind of help peel that back. If any of these spark interest and you want to make a note for a question, we can definitely dive into more of this, but I don't spend too much time on things that you may already be aware of. Look at most contracts. Almost by number, I can tell you the range of where these items are covered. At the beginning, usually going to describe what your services and goods are, what's being transferred, how it's going to be transferred, what exactly it entails, if there's stipulations or other obligations for that. But usually your first section or two is going to be just the material components of what the agreement is contemplating. Consideration usually follows next, right? How much are we paying for that? Or what are we paying for that? How to get paid, when we're going to get paid, what the invoice structure is, so that if there's any issue down the road, it's clear to come back and point to what that is. Third section is usually additional obligations, depending on what type of agreement type it is. But that's when you start looking at confidentiality. Is it warranted what's happening? Who's carrying what insurance to make sure if something goes poorly, it's okay. Indemnification, which is a terrible word, and maybe one of the most unclear things in contracts. But looking at basically indemnifying other parties when you step in to take on a lawsuit from a third party claim. So that's usually where the most high value risk is if somebody else sues your client, it ends up being you're going to step in to take care of that lawsuit for them. So those obligations are kind of tied in neatly there. Then your last area, your standard clauses, usually 12 through 20, will be some kind of combination of your term, termination, how long is the agreement for, is it renewing or not, what does it take to cancel it, how can I terminate this either for convenience or for cause, governing law, opinion jurisdiction. Those are always kind of a overlooked aspect of it, because it's worst case scenario, why would this have to go to court? But those can actually have a pretty big impact on the agreement and the relationship after the fact, depending on which state's law will be looked at, and then even venue and jurisdiction as far as convenience factor and the practicalities of having to do a lawsuit and go through that process. Notices, again, I find joy in the weird nuances here. But notices, I think it can be important as well. A lot of times looking at an older contract template, they'll include notices by facsimile. I don't know who has faxes anymore. I know the offices I worked in previously, usually it was in a closet, and you only get notifications of cruise deals that will come through every now and then. So you want to make sure that you are considering how you want to be notified from a practical standpoint to make sure that something comes through as far as a cancellation or notice of breach. You actually will have access to that. Entire agreement clauses, look at making sure any prior agreements before the actual contract are not considered. So any verbal promises that may have been made or understandings that didn't make it in the contract are excluded. That's also a good time to identify other parts of the agreement, including a master services agreement that has task orders and statements of works and licenses underneath those statements of works. The order of priority of all those terms in cases of conflict, and that everybody knows all the terms that will be included and where to go find them. Severability, assignment. Assignment can be really interesting depending on what side you're on. You don't want necessarily your other party to be able to sign that contract with somebody else for either your services or to do services for them, while carving out the practicalities of being able to transfer the agreement yourself if you are merged or acquired, or preventing them from able to do so. So some nuances in there. Waiver, force majeure. Force majeure came up a lot in the past couple of years, and contemplating what happens in kind of worldwide worst case scenarios. So that whole clause got a new wind behind it on the legal community to figure out, were we protected, are we protected, and can we do better in the future in case of a pandemic, which can actually happen now. In addition to the previously standard clauses of earthquake, fire, government revolt, those things, but looking at what other situations may need to provide relief under that agreement. thinking about that ahead of time, what would happen. Common hurdles, if you're looking at agreements, and again, aren't quite engaging, not sure if you want to engage counsel or not, that I see, so keep an eye out for it, is legalese, which may be weird coming from a lawyer that it's a hurdle, but it really is. There's some Jurassic language left over in contracts and contracting types I don't personally believe with, and heretofores, notwithstanding the foregoing, for clarity. It's hard to read that stuff. And one of the practices I have and continue to have is trying to work through, delete out all the extra words that don't really mean anything. But that can be intimidating, can be risky if you're not exactly sure what those words are intended to mean. They'll throw Latin in there just for funsies. So if you have anything that pops up and you're not quite sure what it is, unlike the business side where you may be able to just move forward and hope it works out, I would encourage you to do a double check for legalese that kind of leads into terms of art. Anything in a contract that isn't written as we consider common English, common language is probably weird for a reason and should throw up some flares that you want to run that by somebody else. Common example is time is of the essence. It's a fine sentiment, and of course time is important, but that phrase, time is of the essence, has cataclysmic impact on damages down the road if a timeline or due date isn't met. It makes you liable for incidental damages if the contract, it happens somewhat often in construction for buildings, if they miss their end date and then the client has to go and rent a new space for 6 months while it's finished, and they missed a shipment because they didn't have the space for it, all those damages actually pile up into the contractor. So it's not a term to be accepted lightly without knowing exactly what the implications are. Along those lines is also anything that's capitalized, because that means it should be a defined term somewhere else in that agreement. And if it's not, you'll make sure you have it defined so you're not opening yourself up to liability that you're not aware of. So anytime that there's a capital phrase, capital words, look at that agreement to see what that actually means. You have to trace that all the way back through where it is defined to know exactly what they're referring to. This is no longer, common interpretation of that word. Which kind of leads over to hyperlinks and incorporated documents, especially if you're looking at any kind of terms online, privacy policies. They love to throw in a quick hyperlink to adhere to their travel policy. It all says a travel policy, little blue underlined words. But if you click on that, there's another 10-page document awaiting review and approval that they can hold you to, because that is also incorporated in there. Any reference to appendices, exhibits, attachments, they are all going to be legally included in that agreement, even if not the paper right in front of you. So it's important to track those down so you're not agreeing to something you're not quite sure what exactly it was. Other common hurdle is practical application. A lot of the terms in a contract are fine legally. It's just a matter of, do we know what that means from a business model perspective? Accepting terms from net 15 and net 30 to net 45, they're all fine legally, but we'll make sure we're tracking that back to accounts receivable to make sure they're aware of that. And then on the flip side, that accounts payable has enough cash and reserve if there's a gap between that payment types. So making sure that not only are we legally okay, that our business is set up to handle this kind of work and workflow is just as important. That way you're not either putting yourself in a bad position with the business, or breaching the agreement accidentally because you weren't aware that you were agreeing to do something in a certain way. Again, adhering to privacy policies. What's the other one? We see a lot of ethics policies a company may have, and they want you to adhere to theirs, which is fine, but it may also directly counter your own ethics policies if you have any in place. So you don't be caught in that in between and not sure which one would be governing, and then not breaching it accidentally. To that point, this is outside the agreement itself, but what I think is very important after the agreement is to make sure you're tracking any actual non-standard terms. Our clients and most companies will have what their standard contract is. It's great. It's built into the business model. Fantastic. They'll have it revised by a client or a partner who will change something that isn't legally an issue. It's no big deal. But if you have it logged and tracked what that change is, 3 years from now, if you want to do something within your business and you're not sure what those implications are for other contracts, you have to kind of comb back through to figure out what it is, or hope nobody raises the issue. But if they do, then you're looking at a breach. Common example for that would be any kind of publicity name and logo clause. It's commonplace to have a term in there that says, either party can use the logo or name of the other party for marketing, promotional tools, whatever it may be. That's okay as a standard term. But if you have a client or a prospect come back and change that to requiring, prior written notice to do so, or they're scratch it all together and say, neither party can use either's, logo or name in marketing in a vacuum, that's a fine term to accept, no big deal. But if your marketing team doesn't have a resource to look back 2 and 2 years to see what can we put in this slide deck marketing one pager, you're not quite sure how that translates through. So beyond the actual contract itself, making sure you're tracking any non-standard terms so that you're in compliance with your own agreements down the road. The other one's risk profile, which is kind of every business's decisions to make. Usually it's based off of what the model is for cash flow, number of clients, risk tolerance, even the founders or investors themselves, know what stage you are in the business. A startup inherently has to have a bit more risk profile. The more mature they get through the process, especially if there's an institutional investor involved, you have to scale back that risk profile a bit. And really that comes into looking at in the agreement, what kind of payment terms do we have? What happens if there's non-payment? Can we survive for X amount of time before we're in trouble? Limitations, liability. It's a term we can talk about more if you'd like to. Basically, it's a disclaimer ahead of time that if this contract goes terribly wrong and there's a suit, are both parties' limitations and liabilities is going to be X amount of dollars, either a specific dollar amount, or if you're looking at common phrasing would be amounts paid or owed over the previous 12 months before the rise of action for the claim. So figuring out how to scale back that liability so that if one customer has an issue, one client has a problem, it can't run up millions of dollars in bills, having that cash flow problem for the company later on. And then warranties as well. How long are we going to warrant the work that we've done, either a service or the product, so that our clients are happy. They know that we're sitting behind our product. But 9 years from now, we can't go back and recode something based off of Internet Explorer 7, which isn't even supporting the Internet Explorer. So kind of figuring out what's important to the company, where most of the challenges would be, and pushback from the clients, so you're not preventing business moving forward, but that you're protecting you and yours with that agreement, again, ahead of time, rather than trying to do it in the back end. So hopefully I can start or stop talking from a wall. If you want to have any questions, comments, concerns on the Maddie, if we can open it up, if there's any questions that have been happening. That was kind of hopefully a helpful overview from the very widest part of the pyramid down to specific points. But I'm happy to if you have any questions, either from the presentation or from what you're going on in the business yourselves. I'm happy to guide however I can.
Awesome. Thanks so much, Maks. Great presentation. And I learned a bunch. I don't see any questions in the chat, but yeah, we definitely invite folks to unmute themselves at this point and throw some questions out there.
It's also time for an applause break if we need one of those.
Absolutely. Oh, we got one. Thanks, Scott. I agree. He did a great job.
Thanks, Scott.
Oh, Jim said, nice overview today. Thanks. Thanks, Jim. Great to see you. Well, Max, while we're waiting for maybe a question or two to come in, what's the best way for people to get in contact with you?
Maks at fourscorelaw.com. We're on the website. Actually, that's not a bad introduction. Fourscore has a pretty in-depth resources part of our website. So if you have any questions, the search function there is great for general information about what's going on. We have all of our profiles there as well. So from our attorneys that are available, my link's on there, phone numbers there. Give me a call, shoot me an email. We pride ourselves in being accessible to clients and prospects. Usually it's time sensitive, even just the uneasiness of not knowing what comes next. So we do try to communicate as quickly as possible, even if it is for everything's okay. We'll talk to you in a day or two, but by all means, reach out to us and check out the website for any resources there. But whatever we do to help out.
Awesome, thanks. Hey, Connor, I saw that you came off mute. Did you have a question?
Hey there, yeah, we had a question here. We just formed a company recently within the past month, and when you guys shared that slide of agreements, a handful of those we're familiar with, but there's the other 40 that we're very much unfamiliar with.
Scary.
I guess, from a first introduction to, working with a business lawyer, do you guys do like free consultations, or, if we just want to kind of like discuss with you, get a general idea of like which agreements we need to start figuring out early versus more down the line, like, how would we start that conversation?
Yeah, absolutely. More than welcome to reach out to me directly. Yeah, we understand that engaging with any partner off the bat, that talking to them first is hard to do and shouldn't be done. So yeah, if you want to do a consultation, kind of describe the business model you're seeing, we can kind of talk about where other clients we've had have had their hurdles with their core documents started as, which is usually where we describe that and make sure that your core business is protected. And then as you engage other folks, we kind of do those as we go. Because usually it's going to be your startup package, your corporation, founders agreements, operating agreements to say, here's our business. It is an entity that can stand alone. And then as you engage either suppliers or manufacturers, making sure that whatever you may be receiving from them are under terms that are acceptable. And then as you hopefully engage clients, we'll peel that back as well, see what kind of sales agreements we're looking at based off of the service or the good. And then employees come along, usually the other way around. Contractors come along, then employees come along. So it does not need to be a startup package of everything you see here on the next slide. But as you're going through the business's operations, these things will probably come up. So just want to make sure you guys have an idea of when those flags should be raised. All right, this is a new type of agreement. This is what its goals are. How do we make sure that we're protected and that we're getting what we want out of it? Sorry, I talked a lot. Did I answer your question, Ron?
Awesome. Thank you. And would you be able to share your email in the chat as well, so we could make sure we reach out?
I got to figure out a new chat function here. So give me a second, I'll give it my best.
Thank you.
Actually, Maddie, if you already have a chat open and are familiar with this format, if you could throw in my email address if you have it, that'd be fantastic.
Absolutely. Awesome. So we have another question. Scott was wondering if you'll be willing to share the slides after. There's a ton of information in them.
Sure. Yeah, absolutely. I think that's, by all means.
Awesome. And then Anthony, hey Anthony, great to see you. Anthony had a question, and it was, my business will focus on selling a live stream network of education and entertainment to senior living providers and others. Definitely working with big companies and lots of lawyers. What kind of lawyer do I need in that type of situation? How do I avoid being swallowed in initial legal fees?
Good questions. I'm biased. I would say the size of your business more or less corresponds with the size of the law firm you want to work with. When you look at the big firms, across associations with that, they can do extremely nuanced, detailed, one-off situations that usually are accompanied with super complex transactions and business types that usually aren't fleshed out during the startup small business high growth yet, right? Because what you're developing hasn't had all those fingers, come out of the model quite yet. We're looking at like a Verizon Wireless. I can't contemplate how many different needs they have from all their agreements. And so having a one-stop shop for them is very different than a one-stop shop for a multi-member LLC who is working on their first profitable services going forward. Usually, like you would think about general counsel, having a general business firm is an efficient way to go. Someone like Fourscore to handle what general counsel would in your business if you had 500 employees. Things like patent, trademark, IP, copyright is usually somebody who is nuanced and deals with that all day long. Same thing with employment law. If you're looking at anything that could turn into litigation, it's very state specific. So you want a firm that has resources according for that. If you're focusing a lot on international, then having somebody who is familiar with what commonly happens in international disputes, also great. But an efficient way to cover a lot of your bases is to have somebody who does your general counsel consultation for the business part, the core agreements, and then engage those folks who work in those more nuanced fields when it comes up.
Awesome, Max. Well, that's all the questions that I see in the chat right now. Anthony said thank you, by the way.
Sure.
Cool. I threw your email address in the chat as well. So everyone feel free to reach out to him. He's a wonderful resource. Fourscore is a great Riot partner as well. We enjoy them being part of our community. So thank you so much for your time today, Max.
Awesome. Thank you guys. Look forward to next time.
Yeah, have a great rest of your Wednesday, everyone. Thank you all.